All right. So once again, welcome to the 2022 November retreat of NDA at Aligunjan. So we'll be beginning our session here today. Um, just to give a brief introduction on the speaker we have today, we have Honorable Justice Roshan Dalvi here. She's a former judge of the Bombay High Court. She has adjudicated a number of widely reported and significant cases during her career as a judge. Justice Dalvi practiced law in Mumbai and also taught corporate law at Jamnalal Bajaj Institute of Management Studies and Narsi Munji Institute of Management Studies. In 1989, Justice Dalvi was appointed as a judge of the City Civil and Sessions Court in Mumbai. In 2004, she was appointed as the principal judge of the Family Court in Mumbai, and she was appointed to the Bombay High Court in June 2005. I would like to request Mr. Nishith Desai to please welcome Honorable Justice Dalvi to the stage.
So this is very wonderful to have you here today. Once again, Shamim, thanks to you. I think we are all connected in a different way as well. Shamim, the better half, of course, I can put that way.
She's the better half.
Yeah, I know. So I think I don't want to be. Behind every successful woman, there is also a man. Please don't forget that. And we've been friends since Government Law College, maybe 1973. So you can see our relationship goes back almost 50 years now, I think. We should celebrate Golden Jubilee of our friendship. And it's so wonderful to have you at the spur of a moment. I call and I say, okay, just make it. I think they've been generous in agreeing to come and talk to us. They can tell us so much about things, the way a new generation has to think and do business and other kind of things, plus how to look at legal profession. And in fact, one program all of you must be aware of that we have is Volintern. Have you heard of that? How many of you have heard of that? Almost all, right? Everybody has. Many of you are through the Volintern program as well. That was inaugurated by Justice Dalvi sometime, I think in 2005 or 6, I don't know, something like that. In a small little auditorium in Nariman Point. And thank you so much. So you can see it has flowered into something, hundreds of students and other people come on the Volintern platform even today. And we are now hoping to have Vol Mentor program. So we'll invite you to be mentors to us, because apart from the legal and the commercial acumen we develop, I think most important thing is mentoring the value system and how you think about the world, how you think about the profession, how you think about. So someday we'll also, and if you have some words to say on that, feel free. It's more a free forum apart from what you'll be talking to us. So just, we have enough time today because we have another colleague of ours to come, but unfortunately he held up. So we have a little more time. And don't worry about that. So wonderful to have everybody. Thank you so much. But welcome. Yeah. And Shamim will also be talking a few points later. You can join. Yeah. Thank you.
Okay, friends, good morning. Mr. Nishith Desai and all the friends. I'm happy to be here with you. And I like to be with youngsters, mainly. Now, you see, you are in a law firm. And whether you are a litigator or a non-lit lawyer, what we always have in our profession is the substantive law. And we all look at, the judgments of the Supreme Court and the High Courts, etc. And we are aces in that. But where we really falter, or where we are yet to come of age, is the practice of management. And this management is required in all professions, but it has yet not come into vogue in our legal profession. Everything is mismanaged. And that is why outsiders feel that our system has completely cracked. It is not working. Just the other day, I was at the K.T. Desai Memorial Lecture, which is organized by Justice Sujata Manohar. And at the end of the lecture, when I met her husband, who is not a lawyer, but who is an engineer and who is a very respectable person, understanding everything, and common man having common sense. He says, from what I hear of this entire lecture, your system has collapsed. Now, why would somebody think so? The main reason is that though we all know the laws and though we develop all of these laws, we do not know how to manage our own work. And I would like you, as I go along with the lecture, to think about how you would be doing some kind of legal work, mainly, and where you might be falling short. So that tomorrow, when you go through and when you come across some new thing, perhaps this would help, and that would be my highest reward. So what, friends, I would want to tell you is that management is required in everything. Today, if you are sitting here without any stress, it is because your mother or your wife or whoever else has managed things in your house. So there is kitchen management also. There is management even amongst the animals, birds, and insects. We fail to realize, but I'll show you the slides. And you would feel that, yes, everywhere there is management, except perhaps in a lawyer's office or in a judge's courtroom. And that is where we have to come of age. And you will also find another thing, that law goes very well with various other disciplines. You can find law in sociology, law and psychology, law and economics, law and finance, law and political science, and various things. But law and management must always be together. And then we would flourish as lawyers, because then it actually enhances our image outside with outsiders. Okay? So as we go along, we find that these birds, you know that they go in V formation. And at sunset time when they are going home, each bird takes a turn. We don't realize that because we have no time to see. But each bird leads the way. This is their management. Without a word, they go on. These are the penguins in Antarctica. They huddle together for comfort because they require warmth. And this is an excellent team management. The monkey and the deer in a forest live together, work together. When the leopard comes, the monkey gives out a scream and the deer starts running. This is their management. Bees, of course, you know, with a very structured lifestyle. And they say that if when in our non-biodegradable world, if the bees go off, within about 10 years, the humanity will die. It is that important for biodegradation. Eagles always hunt in pairs. Their management is to work together, like we do in our offices and in our courts. We work together as a team. And that is, together each achieves more. Team is that acronym. Ants also, we know how well they manage their lives in summertime for wintertime. Then we have whales that communicate over large, long distances in oceans, and they come together, over work. These hyenas, their main management is no planning, because they take the food which is killed by the lion or the tiger. They don't kill themselves. They only eat. That's their management. And all of this, therefore, requires team effort. Okay? So now in a corporation like this, in a firm like this, where there is such a fine team and where you are thinking for the future, one of the aspects that you could think about for the very near future is how better you will manage your work, whatever work that you are doing. Now this management, in management schools, what is taught, this is the basic foundation of management. There are 5 elements: planning, organizing, directing, coordinating, and controlling. There is nothing more and nothing less in management. So if you have to write a letter also, you require all these 5 things. You require to first plan your letter, think in your mind what you are going to write, or an essay, or whatever you are writing. Then you organize your thoughts, you have some sub-paragraphs or whatever. And then you direct perhaps your stenographer, or now today you direct yourself on your computer, and you bring out the phrase. Oh, I'm so sorry. And then you coordinate with whoever that you have to in your organization to send that letter out. And then you control to find out whether the letter has really reached and what is the aftermath of the letter. Okay? Now, these 5 principles which are given by Peter Drucker, who is the management guru, and which is taught in all business schools, is required not only for all these small things and small firms, it would be required even for international transactions. Similar 5 principles, no more, no less. It would be required also to manage the country the size of India. Same 5 principles. Now we will see how we use those principles and how better we can use them to make a better presentation. I'm sorry. So I have taken out, friends, several management principles which are taught in business schools but which are not taught in law schools. And all of these I would like to tell you with certain stories so that I hope you will never forget. Okay? The first is the non-value added items or activities. Now you will realize that in law, especially the litigators, how many non-value added items you put in, how many unnecessary applications you make in court, how many times unnecessarily you defend an application which is made properly instead of accepting that a particular thing can be done so that we can go ahead. A businessman will not do this, but a lawyer does this every day. Okay? Now a businessman, you can see in our country how he flourishes and how our country has come up. But when you see the law firms, you see how everyone says that whatever you do so late that it's of no use. It is because of those non-value added items. Now, when these non-value added items are taught in law schools, how is that taught? One professor comes in the class and he brings a big pot, a pitcher, some rocks, some small stones, gravel, pebbles, sand and water. And the students are just wondering what the professor is doing. He put in the big rocks. Then he starts putting in the smaller ones. And then he asks his students, is the pitcher full? Now the rocks had come up to the top. So the students look and say, yes sir, the pitcher is full. And he smiles. And then he puts in the small pebbles, then the gravel. And the students are amazed. They are looking that, yes, everything is going down. And then he shakes up the pot and he pours some sand in it. Then he again asks his students, now is the pitcher full? And the students are business students, very smart like the lawyers. So they say, yes, sir. Of course it is full. And then the professor picks up the pitcher of water and pours the water until it comes to the top. And then he doesn't ask his students, now is the pitcher full? Because it is really full. He says, what is the moral of this story? So all these smart Alecs say, oh, professor, no matter what you do, there is time and space to do still more. So the professor says, yes, that is a good principle. But that is not the moral of this story. The moral of this story is that if you don't put in the big rocks in your day first, you will never be able to put them in at all. Now please visualize, friends. If you are putting in the sand, if you are putting in the small pebbles and it comes up to the top, big rocks will stay out. But in the intermolecular spaces of those big rocks, the small things can go in. And now let us think in our legal field, how we are going to apply this principle. There are so many things a lawyer has to do. There are so many things judges have to do. And we tend to do the smallest and the most mundane task first, which is the wrongest thing to do if you really want success. Now, you would have some important clients, some clients for urgency, etc., and you would be doing their work. But whilst you are doing their work, how you do it is what matters. So, friends, when you go back to your firm, and then when you go back to court, and I am talking mainly about court because I am not into non-lit work. I am into litigation work till today. Okay? So what I would tell you is, please think and develop that work culture of not doing unnecessary things. Now, just now, yesterday I had this matter where in the midst of my cross-examination in my arbitration, somebody has taken out an application for interim relief on the ground that in that big, large property which they are developing, there is some construction work going on and is going to sell it. It may be right or it may be wrong because everything is a 50-50 case. But the other side wants to reply, then both of them would want to argue, and the real thing is that this person who has taken out this application has taken out at the last minute when he has to come up for his cross-examination. Part of the cross-examination of one party is completely over, and we are now going to the other party, and his affidavit and his cross-examination would begin on the next date. In the meantime, he takes out this application. If I was a lawyer, I would tell my client and I would tell the arbitrator or the court, yes, I will not sell anything now, but let him come for the cross-examination on the next date, as it is scheduled. But no, the lawyers don't do that. The lawyer says, I want to file a reply. If there is an amendment application, the lawyer says, I want to file a reply. There is the Arbitration Act amendment which says all amendments are allowed now. We always allow amendments because this could have come up in the beginning also. It's coming up now. We are going to deal with it on merits. But they will file a reply, obviously to charge the client, and they will waste their time, and then the client will wonder why it was ever done. So that is the image we carry for the wrong things we do. Swiss Air, I'll give you that example, for example. Swiss Air used to always give a cherry on top of the fruit salad. And they found out in their research, and that is how research is important in everything, mainly research of our own work as to how effective we are. That is the best research to do. They found out that mostly these cherries remain in the plates, and the other fruits are eaten up. Cherries cost a lot. So now Swiss Air doesn't give cherries. And they have made profit of millions of Swiss francs by removing that one non-value added item. This is what businessmen do. Now, you know these Bisleri bottles that we have, which we saw in the morning, it has got the cork, you open it and you have it. But if you remember, about 20 years ago, Bisleri bottle had a plastic top, folder on top. We had to remove it with our nail and then open the bottle. And Bisleri thought that this is a non-value added item. I am incurring the costs, but I'm not getting any further benefit. There is no profit. It has done away with it. And we lawyers and judges can do away with many things so that we go to the main brass tacks first. This is the most important principle, management principle for lawyers, I would say. Then, of course, there is core competence, which you know. It may take one whole lecture for talking about core competence. I won't want to do it. But there are specialist lawyers and judges in various countries. Now, in the Lord Wolff report, which we'll come to a little later, Lord Wolff has mainly advocated specialist judges so that the judge has the edge. Nobody knows all the laws. No lawyer, no judge. But all of us know some laws better than others. And therefore, we must have that edge. And by and large now, in law firms, there is a lot of core competence. Okay? Time management. Time management was, in point of time, actually, the first management principle that came about with the Industrial Revolution. When the railways started in England, they had to put in coal, and the railways would work on coal. The man who was putting in coal would be putting in anyway because he's just a laborer. He's what we call a class 4 worker. And the scientists, the management scientists realize that a lot of time is going in this with the result that the speed of the train becomes lesser. So they taught these people how to throw coal. And that was called the time and motion study. This was the very first management study undertaken in this world after the Industrial Revolution. So the time taken for the every motion that you put in. So you're putting in the coal and how quickly the coal can go in if you do it in a right way. Now suppose you are peeling green peas, you will realize that only if you do it the right way, put it one way and another way, you'll do it very quickly, like knitting, for example. So that is the time management. That is how it began. And now there are volumes on time management, but it comes down to this principle. Then there is procedural simplification. Now the simplification is a very good management principle which we don't follow. But simplifying everything in our work, actually not for the lawyers, but more for the judges and mainly the judges in administration, if we find simplified procedures, it's fine. Now, I don't know, friends, can we have some little interaction? Can you tell me which is the legislation today which is completely simplified? No. Constitution of India is only a substantive, basic legislation of our country. Okay? We are talking about simplified procedures. Okay. Okay, data protection law may be simplified. And when you are going to use the data protection law, if there is an offense, if there is a breach, then what happens is what we will have to see. In the legislations which are going on, can you tell us where there is a particular legislation mainly meant for simplification? Yes?
The new labor code which are about to come, and they will replace the existing central labor laws. Those,
Okay.
Four new labor codes which are about to
All right. Yes,
implemented.
it would be simplified, you can say, so that the procedures will become quicker. Any other legislation? Yes? No, I'm not talking about going from one building to another building and doing the same thing the same way. Because as Mark Twain said, if you do what you have always done, you'll get what you'll always get. Yes. Okay, I don't know much about taxation. I don't know how easy GST would be. But income tax, with which we are all concerned, has really become simplified because of technology. Now anyone can go in and everything comes together. If your PAN and Aadhaar card is joined, that is one thing. Any other legislation?
Also, Companies Act.
Yeah.
Yes.
The process of incorporating a company.
Who's speaking? Just if you can raise your hand so I can look at you.
Yeah,
Yes.
In the middle, down below, yeah.
Ah, yes, sorry.
So, the Companies Act.
Yes.
Process for incorporating a company
Okay.
seems to be more simplified now.
Very well.
Yeah, in
That is
furtherance-
good. That is an excellent example.
In
Any
furtherance
others?
In Companies Act, in fact, not just in corporation, but they're also, in fact, for the LLPs, they've already introduced this version 3 MCA. It's a more of a AI-based compliance management system, and that is getting now introduced for company compliance as well by December
Okay.
onwards. So the expectation is that all the regular filings which are done with the registrar, RDs, NCLTs are supposed to be more
Become-
AI-driven. And it will be more compliance tracking efficient system. It's going
Right. Excellent.
Commercial Codes Act to some extent, though it caters
Absolutely.
to,
Very
caters
good.
to a typical category
Yes.
of disputes. But
Yes.
it comes with a lot of schedules and formats.
Yes.
Like a statement of truth is sit in a set format.
Okay.
So it's more convenient and more
Yes.
uniform compared to the affidavits which were filed
Excellent.
earlier.
And even the other parts of the Commercial Courts Act, for example, 12A, which goes to mediation in the beginning, and then especially the summary judgments, which you can have only on arguments. There are so many commercial matters where only arguments are required. Evidence is not required. Evidence is just a repetition of the
In fact,
pleadings.
I generally practice in the Delhi High Court. I'm
Yes.
working in the Delhi office.
Yes.
So these procedures have become so convenient for all the matters,
Okay.
and summary judgment especially has been really helpful for a lot of these commercial suits. So
Very
I'd say
good.
the Commercial Codes Act is kind of a blessing so far. Of course,
Yes.
there'll be issues with implementation,
Okay.
and the timelines are
Good.
being really strictly followed, like with the filings and all.
That has to be followed, otherwise everything cracks up. And what about the Arbitration Act?
Arbitration Act, personally, I think it keeps getting amended all the time, but we are mostly going in the right track.
And I think we need the support of the judiciary in the Arbitration Act because it's still
Yeah,
evolving in India,
true.
though we are
True.
broadly going in that
The
direction.
2015 amendments were mainly for this purpose, the procedural simplification. And of course, various other things like non-value added items, etc. So many things that you don't have to do, so many things you have to do in a particular time frame. And then you have to you have summary judgments now because the Commercial Courts Act is applicable. So all of these things, I think now you know better than I do what is procedural simplification. Procedural, that is required, okay? Then we have the paradigm shift. Now this paradigm shift is a management principle by which you are doing the same thing that you are doing but in a completely different way, okay? So that is a paradigm shift. Now we do so many things wrongly in our courts, in our offices, and we can do them much better. For that, there are various stories by which you will always remember. Now, let us see, for example, the story of the sitarist. There was once the sitarist who played the sitar, practiced a lot, went to his Guruji, and played, and the Guruji was not satisfied. He said, no. Again he tried. No. Again he tried. The Guruji was not satisfied. He was going to give up. He said, if this is not enough, I can't play the sitar. At that time, Guruji tells him, take out the sitar from your right hand, put it in your left hand, and start again. And he did it, and he did it well. Now, this is a paradigm shift, something where you don't require only a cosmetic change, but you require some whole lot of difference. And that is what we require in our justice system and in our legal system. Something completely different to now show the world, to show the people that yes, we mean business and we can do it quick. Then even the story of this vase, the last thing that I mentioned. There was a king and he had a very lovely vase. He said that I want this vase to be painted exactly the color of my room. The painter came and he could not get the exact color. He and his son were working and they made many, many colors on the vase but couldn't get it. The son went to sleep. The old man was painting still because the king wanted it the next day. When the son gets up in the morning, he finds that the vase is exactly the color of the wall. So he thought, why, how? And he asked his father, what did you do? And the father tells him, I painted the wall. The vase did not take that color. So you have to have a paradigm shift. What do you do to get the same color, he thought. Okay. So this is what we require in our work. And when you go back into, especially the litigators in your firm, when you go back to your office, please think of how many things you will be able to do differently. And as they say, successful people don't do different things. They do things differently. Okay. Then, of course, decentralization, a very simple principle but not followed, that each work which has to come about, you have to think about what you can do. Something that your junior can do, you should not do. Something that your senior only will have to do, you may not do. Something like that. And there must be that decentralization in court working system as well as in the firm so that they can unite together. Then the latest first, that is applicable mainly in our profession. We always have this thing about, this matter, the client says now it is 3 years old, what have you been doing? Therefore, I must work for that matter. And you work for that matter. But in the meantime, 20 other matters get old. Even those clients are going to suffer. So if you have a very good case, the last matter can come up first in your dealing with clients, so that man goes home extremely happy. But of course, you will have to do the work for the man who has been waiting for 3-4 years also. In our court system, we have the same way because we have so many cases for so many years. We have got all the time, the thing is, 10-year matters finish up first, 5-year matters we finish up first. But in the meantime, all the other matters get 5 years old. And when they get 5 years old, people who want to take false defenses continue to take because there is some kind of leeway and some kind of profit in that. And people who want to file frivolous suits also file. And we find that about 65% of the suits ultimately are dismissed. That's our statistics. Okay. Then a package deal. Now, generally, in outside businesses, there are many package deals. But we have small things coming up. We say we have to take out this interim application, I will charge you this much, I will take out the interim application. It goes on and on and on, you take out another interim application. But if you are going to ask your clients, can I do all of this, get adjournments, take out applications, and you're going to pay me like this? Or are you going to pay me a lump sum, I'll give you the last decree first? I don't think there'll be a single client who will be telling you that they will want to delay it and you can go on charging them, except only the client who is completely wrong and just wants to delay. So this package deal comes up. Now, in another profession, mainly, can anybody tell me in which profession these package deals have been now coming up very, very clearly for common people? Yes? Pardon? Tourism, yes, okay, I have written. So you are copied. Very well. Now in tourism, do you remember first the tour agents, we used to call them, they used to only book our tickets. We used to get those long tickets with copies, etc. Now we have got tickets on our computers and phones. Then they started booking the taxis when we reach. Then they started booking our hotels. Then they started booking the entire tours. Okay? Now, we have no time to do all of these things. So, we only tell the tour agent that we've got 8 days, we've got this many, we want to go to these 2 places, and you make up a deal. He charges us for everything. Can a lawyer not do that? I will do all of these things that are required, my charge will be this much. So, it's a package deal. The lawyer will be interested in finishing up quickly because he'll get the money, and the client will be interested because he'll get the whatever relief that he wants. Now, a very interesting principle of business is this OODA loop. OODA stands for Observe, Orient, Decide, and Act. How did this happen? This happened in the American Air Force. The fighter jets in America, generally in the Cold War, they were used against the fighter jets of the Soviet Union. And the Soviet fighter jets could go higher and could go faster. But yet, the American fighter jets brought down many of the Soviet fighter jets. So, people were wondering why. And they were discussing. And all those generals thought that, oh, it is because of our training. You know, we train our soldiers so well, Air Force people, etc. One man, Stephen Boyd, thought it is not only training. There is something more to it. So he researched. He waited for many days to find out how these things are working. He made simulations, etc. And he found out that the American fighter jets are very good at changing course. So they would go and they would suddenly change course and come to the Soviet ones. And that is how they would bring down those planes. So he observed, then he oriented, he decided, and he said, this is our real good point, our forte, and we must go on that. So this is the OODA loop thinking. Now, the next principle is sharing business practices. The best practices of each business we share. Now, you've got such a nice infrastructure. If you come across any of the good practices that you are doing, it is good to share it with others. We have our congregations of our judges, etc., and we share each other's practices. Okay? That is good in all businesses, and it would be very good in firms where so many people are working together. So there also you have to emulate the habit of the most successful, they say. Then blame storming. Now this is not blame sharing. That he did something wrong, I didn't do. I'm not talking about that. Blame storming is like brainstorming. So you storm whatever has gone wrong. Where would the blame lie? Not on a person, but on an activity or a thing. And then you find out that it is because of this that generally so-and-so things happen. We in court also have to do blame storming. And we realize in so many matters, say for example in our corporate matters, under the Commercial Courts Act in Mumbai, not a single defendant says, yes, we will go out for mediation. We know that it does not work. So we are now working as to how we will get that mediation into our work culture. And there are judgments on that. And what have we decided by sharing best practices is that, see, when he says no, and when there is an interim application, the legislation says when there is an interim application, you deal with the application. Don't send them out for mediation. So we deal with the interim application. But what we now say is, as soon as the interim application is over, there is no interim application. So now you go for mediation. And this is what has happened in all the other Western countries where mediation has set in very well. In Canada, they call it automatic mediation. So as soon as the interim application or any of the first things addresses are over, the computer takes you to the mediation room. And both the lawyers have to go there so that there is something like face-saving device for whoever that doesn't want to go. You know? So we work out together our best practices, even internationally and of course even locally. Then there are systemic challenges. This comes about in all of the innovative businesses. There are systemic challenges. Now there are three circles. One is the circle of control, where the lawyer, the judge in our system would have complete control. I would know, I would have control in my court that this matter will go on and you cannot tell me no. So that is my circle of control, which is very small. But more than that, we have the circle of influence, is when we can work together with others, when we can influence a thought and get round with people. And the third is the bigger circle, is the circle of concern, which we cannot meet. Now, so many lawyers would not know what to do in a particular court with a judge if he just wants to go on or she just wants to go on. It is your concern. You have to then go in such a way that you deal with the others the way they want to deal with you. Okay? So this is really what is required in our profession to understand which are these circles that we belong to. Then there is single and double loop thinking. It is goal versus task. So single loop thinking is only what? Your client gives you the facts. You put the facts in an affidavit. You tell the court the facts. Nothing more, nothing less. You don't know. You've got nothing to do with your client. But in a double loop thinking, you ask your client various things. How? Why did this happen? And then you get to the real root of the problem. Okay? So that is the single and double loop thinking that we require in most of our matters to give the best of our expertise. Then, of course, performance-related promotions and performance-related payments would be very well settled in a company like yours, in a firm like yours. And it should be there everywhere, even in government undertakings, so that the best merits come up. Then there is legal social service. Now, in your firm, as I understand, there's a lot of social service. But there are still many sectors of social service which you may not have touched upon. And that is required under our legal aid system, under our Legal Services Act. And you can perhaps join with the court authorities. There's a legal aid authority with a district court. And you can join with them and give those services back to humanity. Even if after 10 matters, you can work for one client, say free of cost, of giving the correct advice or anything like that, and come up, that is your legal social service. And continuous education, as you are having even today, just now, and all of the times that you have. Mr. Nishith Desai said that every day you have continuous education, which is an excellent thing, because all the time we are evolving. And team, as I told you right in the beginning, together each achieves more. So in a firm you achieve more, but outside the firm with your opponent also you can achieve more. If you give only a notice and you say that you will be responsible for the costs and consequences thereof, nothing happens with the other side. But if you give a notice and say, this is what my client wants, and can we sit together and work it out and we can negotiate a deal, maybe somebody else would come up. And this is what is happening nowadays, especially in family matters and all that, where we tell them to do it like that. It works very well in commercial litigation also. In Bangalore, the High Court Mediation Center has now joined with the Bangalore Chamber of Industry and Commerce, BCIC. And they have come together in a building so that all the businessmen get the negotiation and facilitation by the mediators. And they are very happy with it. In Bombay, that work culture has not begun. In Delhi, it has begun. I think the lady was there. I think mediation is very well settled in Delhi. Am I right? Yeah, I saw that when I worked there.
So now parties are volunteering also. Once the interim reliefs
Yes.
are, the ad interim reliefs are granted,
Yes.
parties are volunteering. And even recently, the Madras High Court actually set out certain guidelines as to what they believe are urgent reliefs, because a lot of times parties, in the pretext of urgent reliefs,
Yes.
try to bypass the compulsory mediation under the
Yes.
Commercial Courts Act.
Yes.
So I'd say courts generally are trying to be a little more inclined towards mediation, and it
Yes.
saves a lot of time and expenses.
Yeah.
And the incentive that they also offer is a refund of costs.
Okay.
So that also helps.
Yeah, so this works as a team. If everyone wants to do it, you can do it very well. So these are some of the business principles that we can apply. But in our own thinking, what is case management that we are talking about? Lord Justice Wolf in 1996 gave a report on case management, and he set out various things which are today working in England exceptionally well. Okay? So that is what practitioners and judges becoming better at what they do. That is, they do the same thing with less resources and in less time. So the work is the same. It is only how you do it that makes it different. So that is the Lord Wolf report. And that is for these three things: improving efficiency, reducing delays, and cutting costs. And what I would urge you is that when you are thinking and when you are coming together and you are innovating, please innovate ways in which these three things could be achieved, because then you will have really done something for your profession. So the ambit of case management, the management in our system, is two: procedural and substantive. Substantive, of course, requires various laws, and we are very good in that. We deal with the laws, the judgments, and all very well. But the procedural aspect is what we lack, as I told you. And that requires infrastructure, which costs a lot of money. So we depend on technology, and we depend on the government and e-courts and all of those things. But sensitivity is what we have in us. And that doesn't cost anything. It only requires some empathy and some sensitivity. I would call it sentipathy. So therefore, there are various stages for a litigation lawyer. All of these we need not go into. In each of these, you can have, for example, the simplification of procedure. You can have, for example, the non-value-added items which you throw away, and you go to the main item, etc. And you do all of these things right up to the ADR, etc., which is a part of this case management. Okay? I don't want to go into each of these, but I may tell you that things like summary judgments, for example, are judgments on arguments. They are, for example, very important in America, and 90% of the cases don't go to trial. They go on arguments. But here, our lawyers in arbitration as well as in adjudication don't understand that it is so much better to get all the documents together, the contract, the emails, the registers, whatever that is, and ultimately argue, because documentary evidence will always prevail over oral evidence. Okay? And so often we find a lot of oral evidence led, and we can take out about 4 sentences from there, which may be useful. Now, this is a great loss of time, and that is bad work. Okay? So there are all of these things. Oral applications, for example. So many applications can be just done orally. Yesterday in my arbitration, somebody tells me that, okay, we are deciding now we will not have any further evidence, so we will put in a joint purpose that we will go on with oral evidence. I said, there is no need. I'll take down your statement just now only. You want to lead? Okay, I'm keeping it for arguments. Finished. There was no need for any application, oral or in writing. But so many of you, please think, you will be making so many unnecessary written applications, and I would urge you, henceforth, don't. Okay? So costs, of course. Costs are, of course, dependent on the judges, and real compensatory costs, because it must compensate the party who has been aggrieved by all these wrong procedures. ADR is a completely separate thing, and so are the summary suits. All of these things go together. So now we have to remove the roadblocks. When we are thinking about how we are going to have an overall impression, we remove the roadblocks. Pleadings as evidence. In our arbitrations, we now tell them that these pleadings I will accept as your evidence. If somebody wants to cross-examine you, they can cross-examine. Please don't repeat. But of course, if you have anything else to say, by all means say, because that can come. So if suppose there is a private document and has to be proved by somebody, that evidence will have to come because only the author can prove a document. So otherwise, we take pleadings as evidence, which can be done even in adjudication actually. Because in Bombay especially, pleadings consist of submissions, judgments, law, and everything that pleadings should not be. It should be under the CPC, brief, concise, and precise. And it is anything but that. Okay? Now, when it is anything but that, and your evidence is also right inside the pleadings, which should not have been, then there is no need to repeat at least. If, of course, your evidence is not in the pleadings, you lead that evidence. Suppose you say in your pleadings of a 3-page plaint that there was an oral agreement to sell this flat. Then in the evidence, you have to set out where that oral agreement took place, how it took place, etc. This is not pleadings, but we find it in pleadings. And we say now, no more repetition. Then evidence of all witnesses together is now a part of the statute under the Commercial Courts Act. Okay? So we have in our arbitrations also that if you are going to examine 7 witnesses, we are not saying no, get all the evidences together. And you as lawyers, when you are going into adjudication or arbitration, when you are sitting down with your client, you must always find out how many people will give evidence. What will be that evidence at one sitting? And you please remember that that will be the best thing that you can give your client. Formerly in olden times, and not very olden times, I'm not talking about the prehistoric times. It is the times when I started my practice in about 1976. I used to find briefs in my father's office of advice on evidence. I don't see that anymore at all. Now, this advice on evidence is when the pleadings are filed, you discuss with the counsel, you discuss with your client, get all the documentary evidence, the oral evidence, consider everything, and give your actual note on, or advice on the evidence you are ultimately going to lead. At that time, suits may be reaching in some months. Then they were reaching in 2-3 years. Now they are reaching after 23 years. Okay? You are going to forget what your client has said. Your client may die and the sun may come. And I don't know about you and I. But nevertheless, it is always good then to have all the evidence of all the witnesses collected by lawyers at the same time. Don't say, today I'm tired, now then nothing else. Go about, do 5 other matters, you'll forget this client. And that is not service. It is actually disservice. Then there is simplification of proof of documents. That is very essential. Now, all the old, seemingly genuine documents we take on record, not only in arbitration, but also in adjudication. If suppose there is a salary certificate, for example, that comes, we tell them that you give me the salary certificate of the whole year. Now, if one can be forged, everything cannot be forged. If there are rent receipts or electricity bills, we call for all of them together. And then the real genuine things can be seen. And then documents in a group. When there are documents of matters in a group, take them together. Consider them together. It's a very sound practice. Now, amendment of statutes, of course, is not in your domain. These are the statutes and these are the sections which really require amendment. They require to go out of the statute book. But that's a part. And the updation of court fees also is a matter for the government, not for you, but it helps. So I would say, for people like you, if it is to be, it is up to me. And if each one of us does the same thing differently and better, we will have a very good justice system. Thank you.